Hey, this is Jake Hicks from the Law of Esports. Today, I am going to be reacting to Court Cam, Objection, Your Honor, the top 4 moments from the TV show, which I've never seen before, so looking forward to it. Also, thanks, Tom, for letting me use your studio.
This is Jack Garrett, a former chemist for Monsanto, St. Louis-based industrial chemical company, being sued by more than 1,700 people in Harris County, Texas.
Look, this was a big deal. I'm an attorney in Texas. I am licensed in Texas. I live in Houston in Harris County, Texas. This was a huge, huge issue.
Garrett's here today for a deposition.
All right,
when you were at
action.
Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
Was that your title during your entire stay at Texas?
Okay, so just a second ago, we saw, it says Jamel. So this is Joe Jamel, a historic plaintiff's lawyer. He had a case called Texaco versus Pennzoil. If you went to law school, you probably learned about it. But in that case, he won, at the time, the largest award, the largest judgment in U.S. history, $10.3 billion, right? So Joe Jamel won $10.3 billion before this case. So you know that he's a hardcore lawyer. You know he knows how to take a deposition, and he's probably not going to take a lot of nonsense from anybody else in the room.
Stay at Texas City?
Texas City, yes.
Don't talk over each other.
Interrupting is attorney Edward Karstoffan, who doesn't represent Garrett, but represents Monsanto, the company.
After you left Texas.
Okay, that's an important distinction, right? When we're talking about corporate law, if you represent the company, then you just represent the company. If there's a former employee that no longer works at the company, unless they're being sued individually and you have some sort of joint defense privilege, then whatever that ex-employee tells the company's attorney is probably not attorney-client privileged. So you have access to a bunch of communications that you may not otherwise have had access to if that employee was still there, right? So knowing who represents who is really important, especially in a deposition like this, where this guy probably knows some stuff that's going to be really helpful to Joe Jamel's case.
City.
Wait a minute, let me ask a question here.
Yeah.
You represent this guy or not?
See?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know if you represent the guy or not. If you don't represent him, you don't have any right to be making any objection.
Okay, so that's not quite true. If you don't represent the person, you could still make objections to certain questions if they are represented by somebody else or if your interests kind of align. But one thing that's really important in advocacy, whether you're in a courtroom or in a deposition, is control of the room. Can you maintain control of the room that you're in? It's kind of hard in a deposition. There's no judge, no jury, and other lawyers who are probably also sophisticated, but you'll always see attorneys jockeying for control of the room. How far they'll go depends on the attorneys you have in there.
You do represent him, tell us so.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
Oh,
going to do
yeah.
what you want.
Oh, wait.
Do what I want.
No, you're not.
No, you're not.
Yeah, I am.
That's bull.
Whatever objections I want to make, and I'll make them as loud as I want to make them. And you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you want to see how bad you are? Come on.
It's so rare to see lawyers go this hard at each other. Usually people are a little more civil, but this is rare and you rarely see it.
I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
No, I want to know whose side we're on. We're going to be outnumbered, Ed.
I'm going to tell you something else. You don't run this deposition. You understand?
To you, Joe.
You watch and see. You watch and see who does. Big boy.
I'm telling you, Joe.
Oh, you ain't telling me a thing.
No,
But don't be telling another lawyer to shut up.
Don't be
That
telling
ain't your
me.
job,
That's not
fat
your
boy.
job.
Okay, so usually people will try to refrain from the ad hominems. That's generally pretty rare. Have someone calling each other fat boy and whatever. That's, I mean, let's be honest, that's for lawyers, not entirely uncommon. That's pretty rare. God, this is just so entertaining to see though.
Mr.
Get back.
Keys.
I said before, you have an incipient bad
What do you want to do about it?
It's just escalating and escalating and escalating. And again, in a deposition room where you don't have a judge there, you don't have a bailiff there, I mean, sometimes the sky's the limit.
Well, I'd like to knock you on your head.
Come try it.
I'm not going to do
Wait a
that.
minute. Wait
Come
a
over here and try it, you
Wait a minute.
dumb son of a.
Wait just a second.
Yes. Yes. Okay. Really intense. This is just so entertaining to see. When it comes to the actual practice of law, fighting through a deposition physically is not something that you're going to learn in a law school class. But man, sometimes this profession, it's just the passions get ignited and you'll see this stuff from time to time.
Well, I'd like to knock you on your head.
Come
I'm
try
not
it.
going to do
Wait a
that.
minute.
Come over here and try it, you
Wait a minute.
dumb son of a.
Wait just a second. Come over here.
Especially when you're talking about big money. Like, I bet this case was millions and millions of dollars that they're fighting over. And I'm sure people were very, very hurt, sick, injured. And you get attorneys that are passionate on both sides. And again, whenever that happens, you can really get people and see them heated and get them upset with these arguments that just start to just grow and grow and grow until people almost start fighting. I don't know what other professions where you would regularly have these arguments that can just foment and become something more. But let me know in the comments if you guys are working at a job where this stuff is kind of normal. I'd be interested to see.
Thankfully, the two men never came to blows. But after the insults stopped flying, it was Jamail who ultimately landed the knockout punch. Monsanto Company settled.
Okay, yeah, $39 million, right? That's the settlement that they paid. Whenever you have a case over this much money, right? This many people that were sick, injured, then people are going to be ignited. They're going to get hot, and stuff like this can happen in these deposition rooms.
May I see Abdano Hall?
He's just called defendant Abdano Hall, who has an outstanding warrant for resisting arrest.
All right, Abdano Hall. You want to work this out right now, Mr. Hall? Plead no contest. Case is over with. You want to do that?
I'm Abdul Alpha Law, authorized representative, natural person, appropriate persona. All rights reserved. Ex relation Abdul Hall, UCC 1-207/1-308, UCC 1-103.
Okay, so the closed captions are wrong. He meant UCC. This is what's called a sovereign citizen. There's a weird sovereign citizen movement, and it's basically where people cite some archaic and oftentimes non-existent law to try to get out of run-of-the-mill offenses, like for speeding or breaking bond conditions or certain trespassing offenses, public intoxication, etc. People will try and cite these archaic, weird laws that a lot of times don't exist or have since been rewritten or are simply non-applicable to their situation. What this can do is it can really frustrate and annoy a judge. And the last thing you want to have a judge be if they're ruling over whether you get to get out of jail or not is frustrated or annoyed. One thing about the sovereign citizen movement is that their arguments often don't stand up to the slightest bit of scrutiny. Within maybe a couple of questions, you can break down the things they're citing or the law that they are reciting in front of a court and find out that it really is either non-applicable, non-existent, or in a lot of times nonsense.
Do you know somebody named Abdano Hall?
Ex relation, I'm authorized representative, Abdul Alpha Law.
Oh, you're the representative for him?
Yes. Yes.
Do you know where he is right now?
Authorized representative.
No, I know you're an authorized
Abdul Alpha
representative,
Law.
but I need to
Ex
talk to
relation.
him. Do you know where he is?
Really? I object.
Okay, so we're 3 questions in, maybe. I think he asked the same question twice, so 2 questions in, and this guy's argument has already crumbled and fallen apart, right? Not even 3 questions in, and he's already at the end of the supposed sophisticated argument he was trying to make through these rules that may or may not exist. It's already fallen apart. And this judge is trying to somewhat crumble this guy's argument right in front of him. So hopefully when he sees him back again for a bond hearing or something else, that the guy will just be straight up with the court and admit who he is. But it's been a few questions. The argument's already crumbled.
I object to that.
State the grounds for your objection.
I object because I just gave you my natural appropriate persona name.
What is that name?
Abdul Alpha Law.
Okay, let me ask
Authorized
you,
representative.
have you
Okay, so at this point, he's pretty much admitted who he is. He's just going through this nonsense to try and maybe make some sort of case later that he's not who he is. Again, the argument's already crumbled. I imagine this judge is going to just sentence this guy who's in front of him to something. But again, these are often run-of-the-mill offenses. The guy doesn't have a public defender. He's literally just trying to set a bond or something just to get him out of jail. If this guy would just literally admit who he is and nothing else, this process would be 10 times easier.
ever been known as Abdano Hall?
I object to that.
What's the grounds for your objection?
I object
Looks like
Okay, if a judge asks you for the grounds to your grounds to your objection cannot be that you object. You've got to have some legal basis somehow. Objecting for the sake of objecting, I mean, that is sanctionable if you're an attorney doing it.
Well, let's do this. You're Abdono Hall's representative, right?
Authorized representative.
All right, when you see him, will you tell him his bond is $500? Thank you.
Hall is forced to undergo a psychological evaluation, but he serves no jail time.
Yeah, see, no jail time. It was probably some, minor offense, whatever. He just made it way harder for himself than it would have been if he just told the judge who he was. He's already been arrested. He's already in jail. He's in the jumpsuit, already in court. You might as well just admit to who you are and see if you can just apologize and hope that you don't get in too much trouble. I mean, that's probably the best case scenario there.
Next, we're in Denver, Colorado, for the deposition of attorney Robert Abrams.
Depositions of attorneys are always going to be interesting because attorneys are rarely deposed. I mean, most attorneys can tell you if they were deposed 1, 2, 3, 4, 5 times, but it's pretty rare that an attorney gets deposed themselves, right? They may represent parties that get deposed and they may take 1 million depositions, but for an attorney to get deposed, that's pretty rare.
Abrams' firm was added as a defendant alongside their client in a lawsuit between 2 former business partners and are being sued for fraud, conspiracy, and
That's a problem. That sucks. Having your law firm get sued is a major bummer, but also this guy's beard is on point.
aiding and abetting a criminal by the plaintiff.
Good morning, Mr. Abrams.
Man, look at that. That's immaculate. Let me know in the comments, who has a better beard? Me? Mine's a little bit scraggly for this guy. Man.
Do you understand why you've been asked to give your deposition today?
No.
He's already being combative, so you already setting the tone for the deposition.
Asking the questions off camera is the plaintiff's lawyer, Tom Wurge. And on the other side of the table is Abrams' lawyer, Neil Sullenberger.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many?
Okay, again, attorneys rarely get their depositions taken. If they have, they can probably tell you the case, the matter, when it happened, why it happened, right? Him not being able to recall a pretty simple fact this early in the deposition usually will mean that no matter what other questions are asked of him, he is going to have trouble recalling every subsequent fact. That's setting the tone. If you can't get an easy answer early, you know the entire thing is going to be, I can't recall, I can't recall, I can't recall. And it's going to be a very tough, very combative deposition. So you might as well argue this first question before you move on to any others to see if you can even conduct the deposition at all.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question, object to form, move on.
That's, he didn't really answer the question. He said he doesn't recall. That's not really an answer. You can ask him again, and if he doesn't recall, fine. But he also asked the question in a different way. He said, how many depositions have you given? And he said, I don't recall. And he said, do you not remember if you've given any? He says, I don't recall. Those are two different questions.
Have you been deposed
Object to
before?
form. Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master. Good morning.
Okay, so when it comes to objections in a deposition, the reason why you hear object to form a lot is because you don't have a judge in front of you to make a rulings like you would if you were in trial in front of a judge and in front of a jury. So there's only a few objections that you're allowed to make in a deposition. Those are object to form, objection non-responsive, if a witness doesn't answer a question that responds to the way you asked it, or objection leading. So if a party's own lawyer is asking them leading questions, you can object to that. There's a fourth objection, which is attorney-client privilege. If the question calls for information that would be attorney-client privilege, and you can actually instruct a witness not to answer. For the other objections, the witness still has to answer the question. So if I ask something that's improper, the other side objects to form, the witness still has to answer the question. And then later on, a judge will rule on those those objections if we want to put that testimony in front of the jury. So objections to form cover everything, well, pretty much everything, from vague questions, compound questions, questions that call for hearsay, questions that call for an improper opinion, right? That's object to form, but you still have to answer the question. It's not a stopgap. And sometimes if someone's being very obtrusive or trying to delay the deposition by objecting a bunch and not answering questions, you can sometimes call the judge. Here they're probably in federal court, so they're calling a special master who's ruling on evidentiary stuff, but it's hard because you can't always reach the judges right when you need to, or the special masters. And so that's why depositions have a streamlined objection process, because there's not a judge there.
Yes, we are in the middle of a deposition this morning.
But when the special master isn't available, plaintiff's attorney Tom Wurge asks the same question again.
Mr. Abrams, have you had your deposition taken before?
And gets the same answer.
Object to form.
Asked and answered, move on.
Asked and answered is an objection. It's one that will be covered by the object to form objection. But again, the witness isn't the one that's supposed to be objecting. It's just supposed to be the attorney, and the witness is still supposed to answer the question. Now, if it gets to a level where it's harassing, then you could potentially stop and move on and refuse to answer the questions, but it hasn't gotten to that level yet.
Need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep. Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not.
So because this is a lawyer giving the deposition, he knows that harassment's one of the bars to stopping a deposition and getting sanctions. So he's going ahead and calling out the fact that he's being harassed, even though it hasn't really risen to that level yet. He's just playing the game.
I'm
We're going to move for sanctions
I'm
against
asking
you.
you to
If you're not
answer
going
the
to
question.
allow
He just
her-
answered the question.
I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite
30D, it's a federal rule of civil procedure. That's pretty much it. It's Rule 30 of the Federal Rules of Civil Procedure govern how depositions are supposed to be conducted, how they're noticed, if there's a subpoena, what that process is. And then also 30D is sanctions if you try to harass somebody, if you're only deposing them to annoy them, or if you're trying to unreasonably delay the deposition. You can get sanctions, which can include having to pay for another deposition, or it could include other punishments, fines, other things.
quite confident that if any sanctions are entered in this matter, it's going to be against you.
Object to form.
For continuing to obstruct and not answer any of my questions.
Object to
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time.
All right. Unblemished. The problem is if he keeps on being just combative in a deposition, he could certainly be blemished by some sort of sanction, either having to pay the other guy's attorney's fees or having to pay for the expenses of another deposition, paying a fine, etc. Being an attorney, there's not a whole lot of leeway with judges where you know the process and you violate it anyway.
We're going to move for 30D3
We're
sections.
going to move for harassment sanctions against you right now.
We're going to be here for a long time today if you do not answer my questions. I can't even get through my initial questions here because you are being so obstructionist.
That's
today.
because you're a weak lawyer. You have us down here for fraud. Ask us fraud questions.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took?
Object to form.
None of your business. None of
Privilege.
What are those other pills?
Object to form. Object.
Okay, if someone takes pills during a deposition or if they take pills before the deposition, then the deposing party has some right to know what those pills were. If someone took a pill or a medication that could impact their ability to tell the truth or to recall facts, for example, if they took some sort of painkiller or something that made them woozy, made them drowsy, potentially made them forgetful, that's really important to know when you're taking a deposition because you want to know why someone is unable to recall certain facts or if their testimony could change from the time of their deposition to the time of trial. That's a huge one. If that testimony changes, there's a lot of implications there. And so it's not an uncommon question to ask someone if they've taken any medications that could impact their ability to tell the truth or to recall facts. It's not an unreasonable question.
Object to privilege.
None of your business. But I can tell you that if you took some of these, they would help get some of your weight off.
Okay, that's probably an unreasonable answer.
I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Object to form.
If you want to raise your weight problem, Mr. Wurge, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
There's been a weird theme today of chubby attorneys. I don't know why. Also, I don't know why this is the video I got to react to, right? Yeah, I mean, look, attorneys are big boys. Let it happen. It's a big profession.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
All right.
It's clear that you are not here to answer any questions today. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition.
Please do.
After reviewing the transcripts from the deposition, the special master issued an order for sanctions against Abrams. His behavior during the deposition, along with other misconduct in the case, would ultimately earn Abrams a 9-month license suspension.
9-month license suspension. That's a blemish on his record in front of the bar. That's tough. And again, judges have such a short fuse when it comes to attorneys abusing the process, right? If this was a regular fact witness, if this was someone that worked at a company that had never set foot in a courtroom, that had never taken a law class, much less had a law degree, then maybe there's a little bit more leeway for someone being so combative. But an attorney should know better, and judges know that. So when an attorney's being deposed and when they mess with the process, then there's not a ton of leeway. There's not a ton of runway a judge is going to give you before you get sanctioned pretty hard. And I don't know what other misconduct happened in this case, but this guy very clearly ran out of that leeway. Thanks, guys. I really appreciate it. Let me know in the comments what you guys thought. Again, let me know about my beard in the comments, and let me know about if your job also includes some pretty heated arguments. Again, Jake Hicks from the Law of Esports. Don't forget to continue checking out the Attorney Reacts channel and these other videos that we have out here. And we'll see you next time.
Big verdict.